Creditor insolvency expectation gap. What am I talking about? Right, I'm talking about the difference between what creditors are likely to get from an insolvency, a typical insolvency, and I'll come on to that, as opposed to what they might expect to happen. Now, I'm a licensed insolvency practitioner. I'm also a chartered accountant, and I'm speaking as somebody with coming up to something in the region of 25 years experience and been taking appointments for something approaching 20 years as liquidated trustee in bankruptcy. So when there is an insolvency procedure, creditors, understandably, they've not been paid, and in some instances they may be short on information, and they can understandably be extremely miffed and unhappy with the situation. And there is a period of time, particularly where you have a situation where a company is going into insolvent liquidation, for instance, that essentially communication may stop a little bit. In other words, you've been chasing for your money, and directors may have turned around to you and said they've got cash flow issues, and you may have been patient, and then there may be a time between when that communication stops. I mean, maybe they tell you, as perhaps they should, all the time exactly what's going on, but there may be some gaps, and there may be a period of time where you don't really know what's going on for a matter of days and a few weeks in some instances, as the insolvency is brought about when the practitioner is appointed. Because don't forget, the practitioner, somebody like myself, we enter our role as a stranger to the affairs of the company, and we have to gather information and get accounting information, discuss matters with the company's directors, the management, and assemble information for the creditors to, in effect, start the insolvency process. Now, that takes time, and it is not uncommon at all from the point where an insolvency practitioner is, in effect, brought on board to the point in which they get documents out to creditors. That they can be 2 weeks, there can be even up to 4 weeks, and sometimes longer, before that process really does kick off. Obviously, it will depend on the size of the case, and it will depend upon how information is filtered to the practitioner so that they can get on and prepare the report to creditors, the statement of affairs, which is like the up-to-date balance sheet and accounts of the company on a breakup basis. However, that gap may arise in terms of timing. What I'm talking about here is the expectation gap. Now, the standard expectation gap is we get emails from creditors saying, when are we receiving our money? And in an insolvency procedure such as liquidation, where a company is insolvent, you may find that you get no money back whatsoever. There's nothing unusual about this at all, particularly in the smaller cases. It's particularly common. And in fact, there will be the expectations of many creditors, particularly where you're in certain types of industries, whether it's construction, printing, recruitment, all sorts of different areas where creditors will be used to getting hit, and they will provide for it in their business model, they'll provide for it in their credit policies in terms of and what they expect in the context of bad debt. But there are many, many people out there who don't necessarily expect it, and it comes as a bit of a shock. And it's particularly important if a creditor is very much reliant upon a small handful of customers, because that can have a major impact on their business model, their cash flow, and their ability to survive. So many people who expect that insolvency will effectively be a procedure that gets them their money back can be disappointed. Now, it's worth remembering exactly what insolvency procedures in the legislation are actually, well, what they actually say, because they don't actually talk about getting creditors' money back as such. And they certainly don't talk about getting all of the creditors' money back. And in fact, in the context of an insolvency procedure such as liquidation, which is not a rescue procedure, it is a winding up of a company procedure, and it's a process to ensure that certain rules and regulations are followed. There's nothing in that part of the legislation whatsoever that talks about getting creditors all their money back. And it would be extremely unusual if that took place, but it does happen. But what does the legislation actually say? What the legislation actually says, if we take a procedure, there are two common insolvent liquidation procedures. There's creditors' voluntary liquidation, which is initiated by the directors, and there's compulsory liquidation, which can be initiated by the directors, but more commonly will be by creditors such as HMRC, where they've, if you like, had enough, and they wind the company up through the court through a petition. Now, in the case of creditors' voluntary liquidation, what the legislation effectively says is that the duty of the liquidator is to distribute the assets to the creditors in accordance with the statutory order of payment on a pari passu rate basis. And what that means is that the liquidator has to comply with the statutory order, which is secured creditors, then preferential creditors, then another type of secured creditor, floating charge holders, subject to the prescribed part, and then unsecured creditors. And of course, all that is subject to the costs of liquidation. So that's the statutory order of it, and the liquidator has to distribute the assets in accordance with that statutory order. So ultimately, the job of the liquidator is to realise the assets. Now, the problem, of course, is that if we think about it, insolvency arises because there tends to be a shortage of assets, or a shortage of funds available, or a shortage of funds which can be recovered from the assets to pay creditors. That ultimately is one of the core reasons why companies go into insolvent liquidation. Now, if we look at the similar definition of the legislation, which is for compulsories, which is that it is the duty of the liquidator to get in, realise and distribute the assets of the company. Ultimately, very, very similar. And in fact, the duties in, as a matter of what the courts and the case law say, is virtually identical between the two types of procedures. So, ultimately, it is, whilst it is the duty of the liquidator to attempt to maximise the realisations for the benefit of creditors, it is not actually a duty of the liquidator to get creditors all their money back, come what may. That is certainly not what the legislation says. And as I said, it is not that common that a full recovery for creditors of their debt with interest arises. Now, this causes an expectation gap, because what often happens is creditors who are familiar with the company, possibly even familiar with the officers, the directors of the company, maybe have close relationships for over many years. They may even be friends. They may even be, in some instances, connected. Obviously, they may have concerns about the conduct of the directors. For example, the directors are taking too much money out of the company, wrongful trading, illegal dividends, overdrawn directors' note account, all that kind of stuff. And they may expect the practitioner to do more. But the simple fact of the matter is we have the veil of incorporation. And the veil of incorporation doesn't just apply to directors, it also applies to anybody that essentially has control of the company. The company is a separate legal entity from the directors, but it's also a separate legal entity from the liquidator. And what that means is the liquidator is actually not personally responsible in relation to ensuring that the assets can be recovered, and the assets may be claims against the directors. The liquidator is not under a duty to personally finance those recoverers, and therein lies the difficulty. Questions, queries, concerns, give us a shout. We know insolvency inside out.